Are my heirs responsible for my credit card debt in Georgia? I'm Zach Beck, an attorney with Peach State Wills and Trust, a division of the Beck Law Firm LLC here in Lawrenceville, Georgia, and we'll answer that question in today's video. So, are my heirs responsible for my credit card debt here in Georgia? The answer is pretty short, but it does have a little nuance. In short, no. Other people are not going to be responsible for your debts, including your credit card debt, unless they are a joint borrower or a co-signer on that credit card. What that doesn't mean, however, is that your credit card debt dies with you. Your estate is responsible for your credit card debt, in addition to any other valid debts. And your estate is all of the property that you leave behind. The person administering your estate even has to run notice to your debtors and creditors in the newspaper and tell them to come settle up their accounts after you've died. To the extent that your estate has assets, those assets will be used to pay your creditors off before being distributed according to your will or with Georgia's intestate laws of succession. Now, typically, when we talk about your estate settling your debts, we're referring to your probate estate, meaning the property that will pass through your will. This is going to exclude things like life insurance policies with beneficiary designations, as well as bank accounts, financial accounts, and IRAs and 401ks that have beneficiary designations that pass directly to your beneficiaries outside of your will. However, if your probate estate, that is, the property passing through your will, does not have enough assets to pay all of the valid debts of your estate, your non-probate assets, so your bank accounts, your 401ks, your IRAs, financial accounts with beneficiary designations may be called upon to pay your debts. The law in Georgia in this point is relatively unclear. While some other states have laws explicitly defining the liability of beneficiaries of non-probate assets for the estate's debts, Georgia law is relatively silent. What's clear is that the beneficiary of a life insurance policy will not be called upon to answer for the debts of the estate. But whether a bank account beneficiary or an investment account beneficiary can be called upon is an unanswered question. To the extent they could be called upon, they would only be called upon for the amount received from your estate, though. They will never be required to pay out of their own personal assets for your debts. For more information about estate planning in Georgia, you can check out our YouTube channel, and you can download our free guide to estate planning in Georgia at peachstatewills.com.